seated. Okay, good afternoon. This is C 2013-2985, Cecilia Cruz versus Maranda and Roger Randolph. This is a hearing on, there are a number of current motions, and I'll go ahead and take the appearances.
Bill Reisner on behalf of the plaintiff, and the plaintiff is present.
Good afternoon, Your Honor. Dennis Clausen for the city attorney for the defendants who are not present.
Again, good afternoon to you. I have read everything that has been submitted since December, including the exhibits, so I am familiar with the record that has been presented. We'll start with a comment, and then we'll talk through some things, or I'll see if I understand where we are. And then I'll come back to this topic. And that is, I'm wondering if there's a lot of paper being exchanged, a lot of sort of shots being fired between the sides, but I'm not sure whether this isn't spinning wheels for reasons that I'll explain in a moment. Current motions. There's a December 16, 2013 motion for new trial. December 19, 2013 supplemental memorandum in support of plaintiff's motion for new trial. And this isn't meant to be all inclusive, but the motion for new trial filed by the plaintiff asserts that the defendants are still not compliant with the response to the record request, including failing to produce various folders, electronic folders, failing to follow various City of Tucson procedures and policies, failing to alert the IT department of the City of Tucson to the request until August of 2013, which would be after the date of the trial. It occurred, I think, on July 23rd. As of December 5, 2013, according to the motion, there's been no request to the IT department for various folders or drives. And if I'm using the wrong nomenclature, excuse me, I'll come right out and confess to you all that I'm not the most computer savvy person you'll run into, so that's how I understood the motion. The email is dropping off automatically through a system that purges emails at a certain age without any action being taken by anyone to do so. That the City of Tucson can't find two particular files, one of which is entitled Grand Canyon University, that's in quotes, and the other is Project Study, which is in quotes. And no metadata has been produced. Also filed, the second motion, so to speak, is plaintiff's application for attorney's fees, which was filed on December 16, 2013. The third motion is defendant's December 23, 2013 motion to strike the motion for new trial, and motion to a motion to extend the deadline for response to the application for attorney's fees, and the motion for new trial if it's not stricken. The fourth motion that's pending is plaintiff's December 26, 2013 motion for relief from final judgment pursuant to Rule 60C, Arizona Rules of Civil Procedure. For the record, the motion for new trial is pursuant to Rule 59, Arizona Rules of Civil Procedure. This is the Rule 59 motion substantively filed as a Rule 60C motion because the City of Tucson argues in its first motion for strike the Rule 59 relief is foreclosed. That's the fourth motion. And the fifth motion, that's the fourth motion. Fifth motion is December 31, 2013, defendant's motion to strike the Rule 60C motion, essentially raising the same arguments except for timeliness with regard to Rule 59, substantively with regard to Rule 59 motion. Status of these motions is as follows. Only the motions to strike have been fully briefed and are fully right at this point. All right. Now, back to argue at some point here, but I want to just sort of lay out where I am when I'm reviewing all this. Bear with me, I'm not feeling particularly well this afternoon, so. There's a case, and there's several cases, but one of them is Foster versus Camelback Management Company, 132 Arizona 462, 646 P. 2nd 893. It's a Division II case. You can tell, the lawyers will know by the 132 number that it's not new. It's been around a long time, since we're up to about 230 something right now. 100 volumes have come along since then. It's 1982. And it basically holds that the deadline for filing a motion for new trial should be strictly enforced and the time may not be enlarged. However, it goes on immediately thereafter to say that you can treat a 59 motion as a motion for relief from judgment under Rule 60C. So, you can treat it as a timely rule. Let me start. Mr. McLaughlin, do you have a timeliness argument with regard to the Rule 60C motion?
Yes, Your Honor, we do think it's untimely, we think it's belated, and we think it's pretextual in that it was filed together with our response to the 59 motion that was an untimely motion, and was designed to circumvent any timeliness issues and all the other issues that we had raised regarding the Rule 59.
Doesn't Rule 59, or excuse me, doesn't Rule 60C specifically expressly contemplate filing when Rule 59 is foreclosed?
From what, Your Honor, I haven't researched it, Your Honor. From what you've said, I don't doubt that it may say that.
Okay.
I do have a.
None of this is saying. I'm looking at the Rule 60C motion right now in the context of whether the 59 motion can be treated as a Rule 60 motion, because it's not a ruling on the ultimate substantive merits of either of the motions, but it looks to me under that case and also under Rule 60 that there are at least circumstances in which a Rule 59 motion, which would be foreclosed because of timeliness, would then be, could be the subject of a Rule 60C motion. Do you have any response to that?
No, Your Honor, other than on the specific facts of this case, I may want to address
Well,
those, but not on your statement until I can look at it, and I don't know whether you want briefing on this.
well, my point would be that if it's treated as a Rule 60C motion, then it would need to be briefed, wouldn't it?
Yes, I think so.
Mr. Reisner, I assume you agree that it can be treated as a Rule 60C motion, is that correct? I will tell you, I think as a 59 motion, it's probably untimely, isn't it?
I don't know. The Rule 59 talks about newly discovered evidence. And we were here in this room arguing a timely Rule 59 motion. That was when the city said that they had turned over everything. That in fact they had just sent 800, delivered 800 pages. And of course, I told Your Honor that I had no idea what was in it, if they'd done anything, because I hadn't even received it.
It was a Monday hearing and the 800 pages were delivered on Friday.
Right.
I remember.
Right. Okay, so based on the city telling you that they had done everything, my interpretation when this court denied the motion for a new trial, which you seem to have done, that it was based upon your belief that the city had in fact, in spite of, giving false information previously about turning over anything, had finally come clean and had finally turned over all that information.
Well, let me ask you this. My order granted the new trial insofar as the issue of attorney's fees and denied it in all other respects. But wasn't that order an appealable order?
Well,
If it was an error, wasn't it an appealable order? And don't you have 15 days from that order to file a motion for new trial? This may be an academic exercise because I'm looking at a case that says, to me, at least at this juncture, I might be able to treat that as a Rule 60C motion, the 60C motion.
look, I guess the way I certainly see it as, in many respects, an academic thing for sure, because this is a public records case. This isn't difficult in what the city's responsibilities are. And what the city is doing is everything possible to delay, so then they could come in and say, well, the records that these guys want no longer exist. So if I look at something, I don't say, can I appeal and can I go to the Court of Appeals? Can I play the city's game and go on months and months in a case where a judge has already said he doesn't think I should get fees in the first place? So to me, the issue is they have to turn over records and they have to do it prompt. And if they lie to the court, that's either newly discovered information or it's extrinsic fraud and intrinsic fraud, and under 60C, we still get to reopen this thing because we have one goal, which is for the city to comply with the public records laws.
And we're going to talk about that
Okay.
later here.
So-
Mr. Reiser. I'm trying to figure out from a procedural and quite frankly potentially jurisdictional point of view how to treat the motion. And I think I know what I'm going to do now, but I want to give you an opportunity to be heard. Mr. McLaughlin, do you want to be heard on that anymore?
I do, Your Honor, and Your Honor will correct me if I'm wrong. Mr. Reisner is conflating two things that happened at different times. We had a July hearing where I mistakenly told you we had released all the records that I was aware of. We had not clearly done so. I am well aware of that now.
But it continues to expand, at least allegedly. I haven't seen your response.
Right, and I will get to that because I would like to present on that a little bit this
Well,
afternoon.
this may be a shorter hearing than I originally thought, because it might be that I don't hear from you substantively, give you a chance to brief and come back. But anyway, go ahead where you are.
Okay, I will be brief. We did a full motion for new trial. You ruled on that motion. He raised everything he wanted to raise in the new trial motion, and you ruled on it. And now he's coming back with another basis of what he claims is another new trial motion, which you already decided. You actually granted you're right, you granted the motion for new trial on attorney's fees and you denied it on everything else. He's going to keep trying to circumvent and defy the ruling in every way he can. And the 60C...
Let me stop you. Assuming solely for the sake of argument at this point that Mr. Reisner's assertions or the plaintiff's assertions, frankly, I'd rather depersonalize this and not have it be between the lawyers. Assuming for the sake of argument that his assertions are accurate, some of which I stated on the record at the beginning of the hearing, including things like the IT department doesn't find out until August, you can't find folders, emails are purged from the system. Those would be significant matters of concern, wouldn't they, with regard to the quality of the city's response to the request?
They would, except for two things. First of all, a lot of them aren't true, what he's saying. I know you're not dealing with that today, but they're not. And secondly, I want to go back to the...
What about metadata? Was metadata produced? Because I did look.
Yes, metadata was produced, and that's one of the things I would
Okay, I
like
looked
to
at the
present
late
on.
case, and it looks like that looks pretty black and white that metadata gets produced.
Yes, we have exhibits, we gave them an electronic directory, if I may, Your Honor. Very quickly, I would like to.
Actually, before you talk, I'm sorry, I led you down a little bit of a rabbit hole. Finish what you're saying about the procedural posture of the case
Sure.
in terms of the motions.
There was a request on May 12th by the plaintiff, where she made a public records request, including for electronic documents and metadata as one category, and emails as another category. No mention of metadata on emails, and that's going to be important.
Does she have to mention metadata with every category of document?
I think she,
metadata.
I believe she does. When she says it, she creates two categories and then she asks for metadata in one. Yes, I do think she does.
Let me take it to another factual scenario. If you propounded a set of interrogatories to another party in a lawsuit, put metadata in the sentence but didn't put metadata next to it as a qualifier or modifier for every single category of document in the sentence that states a production request. And they came back and they said, hey, we gave you the metadata on this, but you didn't use metadata 6 times in the sentence. Would you say that they had failed to, wouldn't you say they failed to respond to the spirit of the request?
No, Your Honor, no. And if Your Honor thinks that, then I'm going to need to.
That might be a tough sell with most of the judges in a discovery dispute, because I think most of them would look at it and say, term metadata was used. Now, I'm not looking at that, I have looked at that document, in fact, as recently as preparing for this hearing, but I'm not looking at it right now.
Well, let me cut to the.
In the sense that it's not sitting right in front of me, so I can't
Yeah.
see every word you're talking about.
Let me tell you, first of all, most people who request emails don't request metadata. This is not something that we are used to seeing. So our experience is when people ask for emails, they're not asking for the metadata on emails. Also, our technical means of getting emails is a different thing from the metadata itself. We have to, because our system is an old system, producing the emails and producing the metadata for the emails are two different things. The metadata takes a much longer period of time, and probably 3 to 4 times, and we don't do it as a matter of course. Now let me cut to the chase.
So you're not, let me see, you're not doing it right now.
We don't do it as a standard matter at all, and we're never asked about it, and they never complain about it.
Okay, well, but doesn't that just mean that in this particular case, you may have run into a more sophisticated party requesting documents than you usually do?
No, I'm sorry, I don't, because I circle back to she requests it in the context of electronic documents, and then she doesn't request it in the context of emails. So she can't be sophisticated in one sense and not sophisticated in the other.
Can I see the document you're holding? It isn't marked
Sure.
up, is it?
It is marked. It's but it's highlighted for everybody. It's Exhibit 6. I apologize. Exhibit 5. And there's an Exhibit 6, which is her August request, where she repeats the same distinction. I'm sorry. So she asks for electronic documents with their metadata, and she doesn't ask for it with emails.
Did you ever call her up and say, does metadata just refer to electronic documents, or does it refer to everything?
No, I didn't, and in the last 6 months of us releasing it, she never called me up either and said, where's the metadata? Metadata doesn't become an issue until his new trial motion. Now,
Let's come back to the motions. What you got is you got a 59 and a 60. And I guess I'm a little troubled that there's, is Foster cited in anybody's brief?
it wasn't in mine, Your Honor.
I don't think it was in anybody's brief. It's 3 pages long. It took me 5 minutes to find it. So I guess I'm wondering why something as simple as, you can't enlarge the time for a 59 motion, but you can treat it as a timely motion under Rule 60C if you are dealing with newly discovered evidence which by due diligence could not have been discovered in time to move for a new trial under Rule 59D, or for any other reason justifying relief from the judgment. Now, it strikes me there might be a debate or an argument that you're going to make that somehow it doesn't fit either of those categories, but the case law seems pretty clear, and I did check to see if it's still good law, and it is, that you can treat it as 60C, so I'm not sure if we're not just spinning our wheels talking about whether it's a 59 motion or a 60C motion at this point.
Until I can brief it, Your Honor, I'm not waiving anything.
Well, you're not waiving anything, and I'm not asking you to waive anything. Let me do this, though. Both motions to strike are denied. The Rule 59 and Rule 60C motions shall be treated as one motion pursuant to Rule 60C. And Mr. Reisner, you can argue if you want that it still qualifies as a motion for new trial. You haven't waived that position, and this ruling doesn't say that. Your response to that one motion, your motion to extend the time to respond, is granted. The city's response to that one motion, in one filing, will be February 7th, on or before February 7th, because the motion's been out there and you know what the arguments are, and so I think February 7th is a reasonable deadline. And reply would be due February 14th. Since I'm combining both the motions, I'm going to give you 20 pages to respond. Don't feel compelled to use all of them if you do not have to. And Mr. Reisner will allow you a 15-page reply. All right? So that takes care of the two motions to strike. The response to the attorney's fee application, which we're not even going to talk about the substance of today, is February 12th. It's 5 days after the response to the motion. The motion under 60C, and the reply will be due February 19th. Standard page limits will apply to that one.
Your Honor, may I be heard on the dates?
Sure.
We are in the midst of a briefing for the state election date case where it's even years, odd years. Our brief is due the 14th of February, a response brief. It's our only brief. And I'm just wondering if we can postpone my responses here until I've been able to finish that brief.
Okay, well, here's my concern, and you can address this right now. Is there in fact a system which causes data, emails and other data to fall off automatically?
There is, except we preserve the post offices, so it didn't fall off.
Okay, so you are telling me in court, Mr. McLaughlin, that everything can be retrieved?
No, I'm saying if we put a hold on it before it's fallen off. There is a system that makes it fall off. But we were able to, in this case, go back to the post offices, basically reinstall them and find emails going all the way back into, I believe, January or February.
Of 2013.
And 13, yes. I will need my IT people to give me expertise on this, Your Honor, but there is a system where it will fall off, but that was not, I don't believe, a problem here.
So you're telling me that every email back for a year can be retrieved?
No, I'm saying probably every email up to 6 months can possibly be retrieved if we get notice of it early enough.
And I don't need to be flip, sir, but you got a probably and a possibly in the same sentence. So what is it? Can you get it or not get it? Because what I don't want to have happen, since I don't fully understand your system, is I give you more time to respond, and meanwhile this thing's chugging away, having data fall off.
No, my understanding from our IT is that those post offices are preserved right now. And until we tell them no, that you don't need to preserve them anymore, they will stay preserved. Also, Your Honor, I believe we've given essentially all the emails there are to give at this point.
The problem, this is about the third or fourth time I've heard this, and it seems to me there's real argument about whether there's other documentation that hasn't been produced.
I'm sorry about that, Your Honor, but we've looked where the documents are. I don't want to get too into the substance of this, but again, if I may, for instance, on Exhibit 1, for instance, we've given an electronic directory to the plaintiff in September 18th. This is regarding the metadata. If you look at that's Exhibit 1. Exhibit 2, she claims, oh, well, you haven't given us metadata on electronic data. Actually, yes, we have. We gave them a disk, and Exhibit 2 is a PDF document, and Exhibit 3 is a Word document. And what I've given you are screenshots where if you right-click on the disk we gave them, it comes up with properties. And if you click on the properties, you get the metadata. And we're at a point here, we've also, 6 weeks ago, we gave them 500 emails. And let me go through briefly what I found in the 500 emails. 252 of them are duplicates, just straight duplicates. 2 of them are same email sent multiple times to different persons. 56 of them are showing the forwarding of another email. That's all it does. 13, it shows the printing of another email. 62 are constituent contact with council members or the mayor. 65 are direct responses to the constituent by the council member or the mayor. 50 emails, about 10%, are something that may be new. And those are a mishmash. They're mentions in newsletters of Del Rio Golf Course. There are people setting up meetings, interchanges. There's nothing significant that we are finding anymore. And it's also consistent with the fact that it was a staff exploration. We gave those emails long ago. And mayor and council weren't involved. The point is simply this. This is ever diminishing returns. We actually think we've probably given everything that there is. And this will go on as long as they can keep it going on. They want to keep it going on. They never want this to end. We've made a series of voluntary disclosures after what I believe was a full litigation of this case. The only issue in this case that we ever raised was, are there certain class of documents where we may need to not release it because we're still in negotiation? Your Honor ruled on that. We disclosed those documents. Since that order, we've made numerous voluntary disclosures.
Whoa, wait a minute. In the trial, you told me, I think we had 12 exhibits, and I'm not looking at them, but I'm guessing if you counted every single piece of paper, they probably amounted to about 20, 25 pages, somewhere in that neighborhood. Several of them were attorney-client privilege, which I ruled. I think that ruling probably has preclusive effect, by the way. But I think there were about 7, half a dozen, 7, something like that, that were in dispute. You had the Oro Valley fact sheet, you had the Sahuarita fact sheet, or Maranda fact sheet, I can't remember which one. You had the city manager letter. You had the pricing sheet that put out the various alternatives that said if you went with this kind of plan, it would cost this much, and if you went with this, it would cost this much. And I think that was pretty much the gist of it. If I'm missing 1 or 2, please tell me, but I'm not sure it's all important. So I issue rulings say, no, privileged stuff stays privileged, but the other stuff gets produced. Subsequently, made a motion for new trial, and there are these continuing releases, including 800 pages the Friday before the hearing on the motion for new trial. That's a big chunk of documents.
800 pages. And my understanding was you'd already produced a pretty sizable chunk of documents before the trial. The trial was about a very limited number of documents. And it looks to me, at least it's asserted, that there are various voluntary releases going forward. And then even after the filing of the motion for new trial, there's a letter sent to Mr. Reisner or Ms. Cruz, I can't remember to whom, but as a practical matter, it says we can't find 2 folders. Is that correct?
That's true.
What's in those folders, do you know?
The only thing that I know of that's not replicable are certain notes that Mr. Casalemas made about some early meetings he had with Grand Canyon. They have the agenda of that meeting. They've had that since June 21st. We know who was at the meeting, both on the Grand Canyon side and the city side. So that's all I'm aware of from memory, because they were given to me to copy and I managed to lose them. But that's all I can remember that I wasn't replicating either in the electronic directory or in hard copy files.
Okay, let's come back to the original question. You asked for more time to brief,
Correct?
okay? And where I went with that is, are you going to continue to have data fall off the system? And you've assured me that there is no more data that is going to fall off the system.
That's what my IT people are telling me.
How much time do you want?
I would like, basically I would like to, sometime after the 14th, probably into the last week or 10 days of the month.
Have you heard on this, Mr. Reisner?
Judge, I think I filed this motion in first week of December.
December 16th, second week, end of the second week, beginning of the third week.
Yeah. And,
They filed a motion seeking additional time. I held off on ruling until this hearing, so the circumstances are a little different. But anyway, go ahead.
well, obviously, I would take it that they knew they would have to respond to the 60C motion. I'm unaware of any procedure that says you never get to respond and you just move to strike somebody's 60C motion. So they had time starting then to prepare for these things. But I have some additional concerns.
Well, do they deal probably with the issues of documents, correct? Do they deal with the length of briefing?
Yeah, they may deal with
All right, go ahead, Mr. McLaughlin.
length of briefing. Here's the thing. Your Honor said that I could do a 30B6.
Right?
And the city absolutely failed to provide anyone pursuant to the rules on 30B6. They would bring, for instance, Casalemas, are you here on behalf of the city? McLaughlin said, wait a minute, if I had to bring these people, it'd be 15 or 16 people. So all he could answer is what he says. I can answer what I know. Every person, I answer what I know. And then whole categories nobody's there for. Your ruling also said that instead of filing a motion to compel, which would be the ordinary thing, I need to bring it to the attention of your GAA. But I'm also concerned about all of the time and the stuff that's being put in all of these things, and I wanted to get to this hearing. I didn't want to muck up things because I've got, other stuff going on as well. But the existence of the discovery in terms of what other documents were out there, told me that that's relevant to what's going on here. It's relevant when the city wants times to come in and say, well, we're gonna give a response to things later. One of the things that is in my motion that is, I think is as startling as anything, is the project study, this key project, they have a joint email thing which all the documents are in it. The IT guy says no one ever mentioned it to them, they've never asked for it, and it's never been disclosed.
As of December 5, right, I read it. I
Yeah.
think you may have said that on the record, but I know, I read everything you put in your motion.
Okay.
All right, here's where, and this is why I come back to why are we spinning our wheels on this a little bit? What's the preclusive effect, Mr. McLaughlin, of the earlier rule? And they say this, is there a preclusive effect? For example, what's the effect of denying the Rule 60C motion? We'd go ahead and decide the attorney's fee issue, correct?
Yes,
All right.
that's what I would like to do.
Okay, well, hold on. I'm not gonna deny the Rule 60C motion without you responding to it. And, which is not to be construed that I will deny it when you do respond to it. But let me stop and come back to something. Isn't under the Democratic Party of Arizona, Democratic Party of Pima County versus Ford case, 228 Arizona 545, the city's cooperation in good faith or your client's cooperation in good faith a relevant factor related to determining the fee award?
It is if, once we reach the point of him substantially prevailing, which is the first issue that needs to be decided.
Okay,
It could be.
all right. So a lot of the stuff we're talking about would be ultimately relevant, even if I denied a Rule 60C motion, a lot of it's going to be relevant to the issue of attorney's fees potentially, correct?
Potentially.
All right. Now, if I start with, you make the assertion, and maybe it's correct, that the plaintiff wants to keep this litigation going, and in effect, maybe not have it managed day-to-day, the production managed day-to-day by the court, but appoint some sort of IT special master, and I'm not sure Mr. Reisner used those terms, but I'll use it, to oversee the response. And you want to say it's over. This litigation is over, it's done. But I come back to what's the preclusive effect? For example, if I agreed with you, denied the Rule 60C motion, dealt with the attorney's fee issue however I dealt with it, couldn't they serve another document request by letter? Seek the documents? If you didn't give it to them in a month or so, they file another lawsuit and you're having the same situation you're in right here? I'm trying to say, is there a res judicata effect to something that precludes that? And if that's the truth, if they can do that, isn't all this sort of posturing from a procedural point sort of spinning our wheels?
I'm not sure I understand what you mean when you say they can file another information request.
Don't get they send you a letter and say, we now know all this stuff exists, we want it. You haven't given it to us, we want it. You turn around and say, either you can have it, you don't have it, we don't have it, you already got it. Whatever your response is, they turn around and sue you saying another document request. And then either I'm back here with a case, perhaps a consolidated case, or some other judge is hearing exactly the same dispute related to it. What I'm getting at is, what ultimately, you want this to end, they want to keep it going. I'm looking at it saying, I'm not sure that it ultimately, and maybe I'm wrong, and so this isn't the ruling, I'm not sure that it ultimately matters, unless you're going to tell me there's a preclusive effect that would shut down any other request for what they're talking about now.
There's not a preclusive effect to keep them from putting in another request, but I've complied with their request, is my basic position. I've complied with their request. You've ruled on attorney's fees on the only issue that was ever raised or tried by Bill Reisner for his client in July. We said in our answer, that is the only...
I haven't ruled on attorney's fees.
Haven't ruled on attorney's fees, I agree with you. But And our argument will be, attorney's fees as to that issue, you actually did rule on. You said you're not awarding them for that component, and we think that ought to stay the ruling. And we said in our answer,
You interpret my prior order. I granted a new trial on the issue of attorney's fees.
okay,
You're saying there is no, that I have ruled that they can't get attorney's
No.
fees related to the trial on
No.
July 23rd?
I apologize. If I sounded like I said that, I didn't mean to say that. What I mean is, we will argue that that ruling on that component ought to stay as it is. And then we're basically, our position is going to be,
Because I don't think I ruled that. I think my intention, and I think my order is clear, is that by granting a new trial on the issue of attorney's fees, the issue of attorney's fees for the whole case is wide open.
I'm not disputing that. I'm saying we're gonna argue two specific things. One is, there was a trial and you ruled on certain documents, and the attorney's fees component on that component should stay as it is. The other thing that I think we're gonna be saying is, in our answer in June, we said the only issue we're raising is, are there certain documents that shouldn't be released because we're still in negotiation? That's all he tried. And we said, and as to everything else, we're gonna voluntarily release records, which we've done. There was one order that caused us to release certain records. Everything else has been voluntarily released. And he should not be getting fees
Okay, but now-
because we voluntarily released records.
Now you're arguing the substance of the fee award.
Right, I'm just saying, the fee award may be open now. That's gonna be a basic argument. And we think that this case is over in the sense of what the lawsuit was brought on. He brought a lawsuit, go back a second. She makes a request. We said the only thing we're fighting on is, are there certain documents that, because we're negotiating with Grand Canyon potentially still, shouldn't be released? That's what he argues. That's what his lawsuit is about. And it's what all the exhibits to his complaint are about. Now he makes endless motions to try to hook back in and say, no, what I was really wanting to litigate was all this other stuff, which he didn't. So I'm just saying, I think this case is over as far as when we say we've complied with her May 12th and August 16th or 14th requests. She could make another request, but that's irrelevant to whether this case should be moved on and get over with.
Okay. All right, based on your assurance that no further data will be lost, and I'm pretty troubled, more than pretty troubled if data's falling off during this period of time.
And I will double check that and get back to you.
Based on your assurance, the response to the motion, 60C motion, will be due on Wednesday, the 19th of February. So I'll give you a brief extension.
Thank you.
26th of February will be the reply deadline for Mr. Reisner. I'll give you 2 more days to respond to the motion for attorney's fees to the 21st of February. And I'll give Mr. Reisner 2 more days to file this reply to attorney's fees on the 28th of February. Same statements about page limits will apply.
So 20 for me, Your Honor, on the,
You can go 20 on your response to that one motion, Mr. Reisner can go 15 on his reply. Now, let's talk about another hearing. Because initially, when I issued the order saying it's granting the new trial, I left open the possibility of doing this on a paper record. But I'm not going to do it on a paper record. I'm going to grant a hearing. I think actually I'd like to hear from both of you on the issue of attorney's fees. And you can also argue at that I can give you the entire, well, I can give you 2 hours on March 10, that is a Monday, 2:30 to 4:30. Or I can give you 3 hours, 1:30 to 4:30 on Monday, March 24. This would include the presentation of any evidence that people wish to make on the issue of attorney's fees. And so, Mr. Reisner, your thoughts, March 10th or March 24th? I'll tell you, I have a feeling that 3 hours is probably more reasonable than 2, given what I think is the level of contention in this case and some of the other issues. And I really would like to do this in one sitting, so.
Well, I agree with the 3-hour piece, but I want to bring up discovery again a little bit.
Okay, well, let's finish setting a trial, and we'll talk about discovery.
Okay.
March 24. Mr. McLaughlin, does that work?
March 24th is fine, Your Honor. I did want to ask, my attorney's fees response is going to be rather elaborate. Could I ask the court's indulgence to have 20 pages on that? There are arguments that I want to make that I think you're going to want to hear,
Well,
that need some elaboration.
I'll give you 20 on your response, Mr. Rice, and I'll give you 15 on your reply. Right. Okay, so let's recap. Both motions to strike are denied. Okay. The defendants have until the 19th of February to file their single response, not to exceed 20 pages, to the Rule 60C motion. I'm treating it as one motion filed under Rule 60C. Plaintiff will have 1 week to the 26th to file their reply memorandum, not to exceed 15 pages. February 21 will be the deadline to file a response to the application for attorney's fees, not to exceed 20 pages. February 28 will be the deadline for the reply memorandum for the application for attorney's fees, not to exceed 15 pages. March 24, 1:30 in the afternoon until 4:30 in the afternoon. That will be the new trial on the issue of attorney's fees, and it will also include oral argument on the 2 motions. I will look for the one. It's also further ordered that the 2 of you will speak with each other about preparation for that hearing, what witnesses are required, and an equitable distribution of the time at that hearing for presentation of evidence. And now, I'm trying to think if there's anything else we need to do with pending motions. And of course, the briefing schedule is, as I indicated, in reliance upon the city's assertions regarding the loss of further data not occurring in this period of time, so that there won't be any further data loss, if in fact there has been any. Mr. Reisner, you wanted to talk about discovery?
Yeah, Judge. You know, one of the, I think, big problems that's come up in this case is that the court has created a situation where they, thanks at the invitation of the city, where the plaintiff's, hands have really been tied. There was an initial order that we.
I'm smiling, Mr. Reisner, you haven't created any of the situation we find ourselves in?
Excuse me?
You haven't created any of the situation we find ourselves in?
I don't think so, no.
All right.
You know,
I personally think that what strikes me as a high level of contentiousness and perhaps personal dislike for each other between the two of you has contributed to some of the issues we're dealing with right here. That's my observation. Obviously, I'm not privy to your communications, but that's my observation.
Well, Judge, then I'd like to recap a little of the history of the case.
Just tell me your discovery, what you're talking about in terms of discovery.
Yeah.
I mean, I can recap the history of the case too, Mr. Reisner, including the fact that quite a bit of time at the trial was spent talking about issues that were related to TRIO and other entities and who does what and everything else, which pretty remotely are tied to the document request. It strikes me that you have been trying to expand this a great deal. Now, I'm not closing my mind to the idea that you've been not been the subject of good faith response. That's to be determined as we go forward in the case. But I think it would be a little unfair to say that you haven't been trying to expand this beyond issues of the documents. And to be really honest with you, Mr. Reisner, we've known each other for a while. I don't appreciate things that say that I've been duped. Okay? And I don't, either in writing or in court. I don't appreciate that. So you can go on with your argument. All right?
Okay.
Thank you.
Yeah. I had said in this case, I achieved that. There was a court order that I could do depositions. I set 2 depositions of the defendants. A motion was filed by the city for a protective order that resulted in Judge Lee granting the protective order, and I don't blame him because the city said in its protective order motion that the city has now fully responded to the public record request, except it's withheld 7 documents from release. And I believe it's reasonable for the court, when the city files a motion saying that they've turned over everything except 7 documents, that the judge might say, okay, then there's no need for deposition because the city's said they turned everything over. And I view that as saying that the city duped the court because the city told the court something that was not true.
I read that in your motion, and I remember the motion for protective order, and I realized the trial went ahead without depositions, all of which is potentially relevant to the issue of the city's good faith or lack thereof in connection with the attorney's fees issue.
Sure.
So, and I recognize that fact.
Okay.
But I guess the question then, you brought up something earlier that I'm actually interested in right now, because I ordered a Rule 30b-6 deposition. And as I understand Rule 30b-6 depositions, a party needs to produce a witness to speak, one or more witnesses to speak on the categories at hand, and that witness speaks for the party. In other words, they're bound by what occurs. And you're telling me earlier in this hearing that didn't occur.
Yeah, I'm telling you, I'll tell you that at every single category, the city absolutely refused to do that and to comply with its obligation under that. And I certainly would be happy to specifically outline that. But the thing is really, is that I've attempted at all times to limit this thing. Now, if we can go back to the trial judge, the trial had one issue, which was the city said that if these documents in the folder were revealed, that would bring things to a halt in the city and how they did business, that the city wouldn't be able to proceed and so forth. So what you were objecting to that was beyond what is just what do these documents exist, it was the city's defense. We had to go into those matters because that was the city's defense. The court needed to weigh the city's argument of why the city would be harmed against certain things from the public of why they needed that information. That's because of the city's defense. That's why that trial was the way it was. What I want the city now to do is to say, look, the judge was right. I could, 15 people could send a letter over to the city and say, we want the information that's in this shared drive that you never today have turned over. If they would turn over the stuff, think of all the time that would be saved if the city would just do what the law requires them to do.
So you wanted to talk about discovery.
Yeah, so what I'd like to do is to then file the motion to compel, or let me get a deposition where I can find out in terms of, the city says these things, and then turns out later, it isn't true. I mean, believe me, I was shocked when someone from the IT department comes in and says, no one ever asked for this stuff. Even on the emails. Well, the city told me to look at stuff, but I don't remember what it was I was supposed to look for or who I was supposed to. It's that kind of stuff and the difficulty for us to unravel this thing.
Mr. McLaughlin, a couple of things. I recall from the briefing, there is some testimony by Mr. Casalemas when he was asked pretty standard questions that you would ask a Rule 30b-6 witness. That he's not there testifying on behalf of the city, he's testifying on behalf, he's just telling what he knows.
Well, he's our designated 30B6 witness, and yes, he's telling what he knows. He was the main city manager contact who dealt with this issue. Now,
Wait. Doesn't Rule 30b-6 contemplate producing a witness who knows, including the possibility of producing a witness who goes out, does research, and is instructed concerning certain topics? In other words, it most comes up with a corporate entity where you're taking somebody who is going to testify on behalf of the corporation on the subjects delineated in the notice. And that person may or may not know all about them on a first-hand basis, but they go and they look and they find out. And then they turn around, they come in, they testify, and what they say binds the company. Isn't that historically the effect of a Rule 30b-6 deposition?
I think that is part of the rule. Mr. Casalemas was our designated witness who had the personal knowledge. We also gave two other witnesses. I don't know how elaborate an answer you want from me on this.
It sounds to me like Mr. Reisner's saying he didn't get a full 30b-6 deposition.
He got 6.5 hours of 30B6 deposition from 3 management level witnesses. Chris Casalemas from the manager's office, Hector Martinez, our real estate officer, manager, and DJ Parslow, our deputy director of our IT department. He spent half the time in those depositions doing exactly what you said he did at trial, which was going into things other than documents, arguing with our witnesses about what things meant, trying to get explanations of appraisals.
Mr. McLaughlin, what I said was he spent a lot of time on some things that seemed remotely connected to documents.
Well, he did the same thing in the 30B6s. And so my point is this. We gave him 3 30B6 witnesses. Your order said if you have a problem, don't seek protective order, make a phone call. I don't remember any phone calls or protective orders sought by Mr. Reisner. Now we're 6 weeks later or 2 months later, and he's trying to tell you how he didn't get a fair shake on 30B6. He's not a very good deposition taker, and he didn't get what he wanted.
Hold on. Hold on. That's a personal shot.
I apologize.
Which is inappropriate.
I will withdraw it. So my point is this. He did a 30B6. He had a full 30B6. I think 30B6 is only 4 hours. And another thing it contemplates in theory is only one witness. Well, we said, you've got various categories of...
No, well, it doesn't contemplate one witness. People produce multiple witnesses all the time.
And we did. And we did for that reason. Because he had a long list of things he wanted. As far as we know, he got everything he wanted out of the deposition. I haven't heard anything more about the deposition until today, when he says he needs more depositions. He doesn't need any more depositions. He's got all the information he needs. Again, he's expanding the case, and it's gonna be endless.
It's not gonna be this. All right, Mr. Reisner and Mr. McLaughlin, you're gonna meet personally. It's hereby ordered, you're going to sit down personally and discuss any disputes you may have concerning that Rule 30b-6 deposition. If you conclude that there are areas of that Rule 30b-6 deposition which you don't think you were given an appropriate hearing, an appropriate witness on, Mr. Reisner, I'll authorize you to file a motion to compel. But you're gonna sit down, that will take place no later than February 7th. You will meet in person, not on the telephone, and you'll discuss your disputes concerning that Rule 30b-6 deposition, and you'll make good faith efforts to try and resolve the matter. And then, if not, you can file a motion to compel Mr. Reisner. You can file a response in the due course, and I will then reply memorandum, and I'll deal with the motion. All right? Anything else, Mr. McLaughlin? You're rolling your eyes like you don't think you can sit down and talk to Mr. Reisner. Mr. Reisner didn't
No.
look terribly thrilled either. It strikes me,
No,
particularly given what you said a minute ago about Mr. Reisner, to be rather compelling evidence of my observation that you two don't get along.
I don't believe I was rolling my eyes, Your Honor, but if you perceived it, I'm sorry. That was not what I was doing. I mainly was interested in, when you rule on the 60C, let us hypothesize you grant a 60C. What is the posture of the case at that point? Are we still dealing with an attorney's fees hearing?
Well, then, you're gonna argue that 60C the same time as the attorney's fee hearing.
Okay,
All right.
okay. So it'll be one argument.
But let's come out and say hypothetically, this is where I was going to with my questions about spinning wheels and can't they just file another request? I mean, you're trying to say it's over, they're trying to expand it. I think that's an accurate assessment of it. Bottom line is, can't they just file another request and file another lawsuit?
Yes, Your Honor, and actually, linking it all together, I'm wondering if when we meet, you could order that if Mr. Reisner and his client have specific items that they want to know about or that they think we have, that we hear that from them so that we can try to respond to it? Because we think we've responded.
Well, I think there are a couple that I've already heard. Metadata. You say they haven't asked for it.
I say
Two files you say you can't find.
I say we've given them part of the metadata they've requested, and then there's some that they didn't request. And if we're willing to cooperate with them in trying to find metadata, if they have specific documents, two caveats: I don't know that things aren't going to still be findable every time. And the other thing is, in the case that we've preserved things, but it may have gotten rolled off before. And then the other thing is, if she asks for every metadata of every email, that's going to take a lot longer than saying, I need these 50 emails metadata. So I would like to try to resolve this, but I don't want generalizations. I want specific things that she thinks we can give her that we haven't.
Mr. Reisner?
Yeah, Judge, I'm sure we could meet, but he could start by reading some of the pleadings I filed. They've
this, but I don't think that process makes sense, so pardon me for thinking out loud on it. All right, is there anything else we need to discuss this afternoon?
Not from the city side, Your Honor. Thank you.
Mr. Reisner?
no, Judge, except, I'm not so sure that's not a bad idea.
Am I thinking out loud idea?
Yeah, look, we want documents. And we can point to the documents we want, and they just need to do it. And here I've got another 2 or 3 months of stuff, and a hearing is about all of this stuff.
Well, you wanted a new trial on the issue of fees, and you've now got one, an actual live testimony trial on the issue of fees, so.
But I wanted a new trial on that was one motion. The second one was a new trial based on the fact that we know that they haven't turned over the documents.
Well, let me ask you this question. I appreciate, by the way, I appreciate both of you going back and forth in the hearing today, notwithstanding the tension. I do actually appreciate the willingness to answer questions, so thank you. You want a trial on what they are required to produce? This is a document production case. Or you want me simply to rule that they are required to produce? What exactly were you looking for?
What I absolutely have learned, I believe, at least so far at this thing, is the key documents that we want and that we initially asked for. I mean, there couldn't be a bigger category than the group email system where everybody working on that project and where documents were put together in the manager's office. The IT department says those things exist. We've asked for those. 8 months later, the IT department says, no, the city never asked us for that. Yeah, we still have that information. It's not been asked for.
Yeah, that's the, it's Mr. Parslow, right?
Yeah, the shared drive, that's the main stuff. He says that stuff's there, and the city has never asked us for it, and so of course they've not turned it over.
And your response, Mr. McLaughlin, would be it doesn't fit within Ms. Cruz's request?
No, Your Honor, if he's talking about a shared drive directory, that was in the city manager's office, and we gave it to them on September 18th with the metadata in it.
Don't argue with each other.
Sorry, yes.
All right?
Yes, September 18th, we gave them that directory. It wasn't an IT directory. It was, well, it's an electronic directory, but it's available through the city manager's office. They gave it to us. Mr. Reisner and his client keep talking about things as if they exist. I don't know if they exist. There's other things that I know exist and that we've given to him, which he insists, well, the IT department didn't give it to me. Well, directory is a great example. That was a shared drive created by the manager's office. They've had that for 4 months with the metadata. This is the kind of circularity that I can't respond to because I don't know what he's talking about. I've either given it to him or he's saying there are things out there that in all of my searches of emails, hard copies, electronic directories, either I can't find anything like that or I know I've already given him things.
Well, I'm not going to issue any more rulings today other than what I've done. So we've got the schedule, you've got the rulings from today, you've got the orders from today, and we'll go forward from this point. Is there anything else to discuss?
No, Your Honor, thank you for your time and
Mr.
help.
Reisner? All right, thank you very much. Have a good afternoon.
Same to you.